Hello friends, welcome to VSP Law channel. Thank you for clicking this video. Today we are going to discuss Supreme Court citation regarding the abortion. A recently judgment, a significant judgment given by the Honorable Supreme Court of India regarding the abortion of a woman. So, abortion is treated as a right to the woman. So, and this rule case law is that the petitioner versus the Principal Secretary, Health and Family Welfare Department and another SLP Civil 12612 of 2022 dated 29/9/2022. A judgment delivered by the Supreme Court while interpreting the law of M.T.P. Here is the M.T.P means medical termination of pregnancy. So, come to the point wise we are discussing judgment. The first point from this judgment, so section 3 subclass 2 subclass B of medical termination of pregnancy act 1971 and rules 3B more medical termination of pregnancy rules 2003 interpreted by the Supreme Court regarding the abortion of the pregnancy of a woman. So, if a woman having a pregnancy for a period of 20 weeks to 24 weeks, then she has a right to removal her pregnancy by way of abortion without permission of any others. It is a right of woman to make an abortion. So the second point is that should not show the discrimination between the married woman and unmarried woman. If show the discrimination between the married and unmarried women, it is against the spirit of Article 14 of the Constitution of India. Article 14 of the Constitution of India says equality before justice. So it means there must be a equality. There should not be a discrimination between the married woman and unmarried woman. So equality should give it. And the next point is that, so here is the marital rape, a new concept will bring in the purview of the section 3BA of Medical Termination of Pregnancy Act. Previously, the term is not included, but now the term of the marital rape included. It means it is in purview of the section 3B subclass B subclass A of Medical Termination in Pregnancy Act 1971. So that here is the marital rape means if marital woman means wife was raped by her husband without her consent, it is treated as a marital rape. If she have a pregnancy due to that result, then she has a right to remove her pregnancy by way of abortion without consent and knowledge and permission from her husband. So she can remove her pregnancy by way of abortion. It is a right confirmed by the Supreme Court while delivering the judgment. And as per medical termination of pregnancy, the woman was categorized by the 7 categories women are there. So married women and raped victims and disabled persons and minors, and top 7 categories are there. If they have a pregnancy for a period of 20 weeks to 24 weeks, it means 5 months to 6 months, then they have the right to remove their pregnancy by way of the abortion without consent and knowledge of the any others. It is a right to her. So next, here is another point. Minor, here is that unmarried women, especially unmarried women and widows having the 20 weeks of pregnancy, they will remove the pregnancy by way of abortion. In this judgment, the court has increased from the 20 weeks to 24 weeks. It means unmarried women and widows, if she has the pregnancy, then the period of 20 weeks or 24 weeks, then she has a right to removal her pregnancy by way of abortion. Previously 20 weeks, presently 24 weeks. And the next point is that dreams of the married woman and dreams of the unmarried is the same, like they are dreaming for children only. Should not show any discrimination. If it shows the discrimination, it is against the spirit of the Article 21 of the Constitution of India. It means Article 21 what says? Personal liberty of the individual. So that married women have the personal liberty to have dreams for children. The same way unmarried women have a dreams for children. See, here is the liberties. Personal liberty should given. If personal liberty is not given, it is against the Article 21 of the Constitution of India. So that it means you should not show the any discrimination regarding the personal liberty of the married women or unmarried women. And the next point is that in case of minor can remove the pregnancy by way of abortion. While removing the pregnancy, there is no need to identification. Details of identity is required. Previously, there is a identity is required. Presently, as per this order, Supreme Court order, should not ask any identity of the details regarding the pregnancy of the minor. So, this is a significant judgment given by the Honorable Supreme Court of India to confirm the right to the woman for removal of a pregnancy by way of abortion, and also categorically stated that the woman have a right on her body only. Nobody can have a right, even though husband does not have a right. Women have a right on their bodies. Means we have to respect the women, and we have to provide a security to the women. So this is a significant and a sensation judgment given by the Honorable Supreme Court, and for making the abortion. This is a judgment, recent judgment, and interpreted the section 3 subclub 2 and B, and also rules 3B of medical termination of in pregnancy act rules 2003, interpreted by the Supreme Court while delivering the judgment. This is a sensational judgment. Friends, this is the topic. I hope you will get a satisfaction. If you get satisfaction, you can give the like, share, subscribe to the my VSP Law channel, and please forward to the social media, and it will be useful information to others. In coming videos, we have to discuss the ruling citation by case laws. If any other information, if any corrections in this regard, you can see that in the description. If it is there, I will put any point and further information or any correction I will mention in the description box. Please follow. Thank you watching this video. Thank you one and all.